Well, this time we're going to talk a little bit about responding to a complaint. And, the simple answer to that is the answer. But there's a lot of other different kinds of responses. So we're going to try to work through some of those. Obviously, the one, direct one is the answer. But there can also be a motion to extend the time to answer. Okay, that's another one. And then also there is what we call a motion to dismiss under Civil Rule 12b-6. And what that's saying is that it's unclear. It's basically, let me change this a little bit. It's failure. It's alleging failure to state a claim upon which relief can be granted. So basically, trying to shift the burden right back on the plaintiff to say, well, he didn't do his complaint right, he has to amend it. Response to that motion is usually giving the plaintiff time to correct that failure. So it doesn't actually usually resolve the entire case. There are ways that could happen, but usually what it does is it triggers what we call motion for summary judgment. One of the things on motions to extend, usually there has to be an answer filed within, in federal court, 30 days. In state court, it's changed, it's different dates, 28, 23, or 20, depending. If it's personal service, it's different than if it's publication and so forth. A lot of people I know have just gone to 30 days. Just say, you got to file an answer within 30 days. But, that's not specifically following the exact rule. Okay, so a lot of people then, in order to avoid this, they may claim, well, we don't have enough information yet to file an answer because we have to get the file from the insurance company. And so a lot of times they'll give them the right to an extension. So that is a problem, and that does happen frequently. It happens, in fact, most of the time. The other thing is, in the old days, they had a thing that was called a demurrer. Demurrer basically it's out of date. It's not done anymore, but it was very common. It's still available in some states, and basically what it is saying, I just don't know enough at this point to be able to file an answer. So basically, the demurrer in Indiana has been basically set aside. You're not allowed to do demurrers anymore, but instead they're using the motion to extend. Here again, saying we're still collecting the facts and so forth. So some states still have that, but we don't use that in Indiana. Also, time limits. We said, there are some states that allow an automatic default, but those require 60 days instead of the 30 days. So. But in Indiana, it's in that range between 20 and 30. Okay, an answer basically challenges the plaintiff's right to relief, may say that they deny all the facts. Sometimes it's hard to deny all the facts. I mean, there was an accident, it happened at State Road 9 and County Road 500, but they may say but the defendant was not negligent, the plaintiff was negligent. So it depends on the specifics, but I've seen answers set up where the first answer is they just deny everything, and that's just a kind of a blanket thing if they leave anything out. The second answer is that they only deny the specific facts. Now, there are some jurisdictions that's, like I said, in the plaintiff side, in 5, that you can be accused of a frivolous complaint. Well, there are now jurisdictions that are saying that you can be accused of a frivolous answer. So you've got to be careful and be specific and be exact and, be truthful in your answer. And again, you can always amend your answer. And especially if the plaintiff amends the complaint, then the defendant is always given leave to amend the answer. So it gets kind of a little bit complicated here with time. Once again, be good if you could share a sample answer. Sample answer might be good as far as telling us, basically how it's done in your county. The one had a straight line in the middle. The other one had the right parents. Like I was saying, I've seen them with stars. I've seen them all. So basically, as far as drafting, the heading is going to be basically different in different jurisdictions, and a lot of that is going to affect, where you work in the end. I mean, that's what's going to determine how you do that. But we can try different kinds and just kind of share those. Now let me say something to you right here, and this is critical. I meant to mention that last time. The copy of the complaint and the copy of the answer needs to be in your trial notebook. And some people are like, well, how can I be the plaintiff and the defendant both at the same time? Well, what I'd like you to do on this, and I think this would be really good, is to team up with one other person in the group. Maybe you've had a class with them before, maybe they live in your town, I don't know. But try to find a friend where you can share. So basically, you'll do an answer to their complaint, and they can do an answer to your complaint. Because when we work in this field, we're going to be working on multiple cases. So they could answer your complaint, you could answer their complaint. And it might make it more interesting as far as an experience than just doing your own complaint and then answering your own complaint. That might be difficult to understand. So if you want to do it that way, I would really strongly recommend it, that you work together on complaint and answer, because this is one area where it really there are going to be two different paralegals, one doing a plaintiff's complaint in one firm and another one doing the answer in the defendant's firm. So something to consider. I think it's a good idea. Here again, always need a caption, like we said. Some of them have the heading in the middle, some of them have the heading on the left, some of them even have the heading on the right. Caption, allegations, in other words, there can be like a general answer, which is a general denial, single paragraph, just deny everything, or you can have affirmative defenses where it's very specific, things like accord and satisfaction, duress, estoppel, failure of consideration, fraud, payment, assumption of the risk, and this is going to come up in a lot of negligence cases. Someone gets hurt at a ball game, they're always going to say assumption of the risk. Contributory negligence has been outlawed in Indiana in most cases, except perhaps school cases, government cases, this type thing. Comparative negligence, always going to come up. So you want to allege the affirmative defense of comparative negligence, saying that the plaintiff's negligence exceeds the defendant's negligence. So that's important. And there are other specific rules set forth in the rules of civil procedure that you might want to take a look at and incorporate in your answer. But if you're doing an answer to a slip and fall or a car wreck or something like that, definitely include the comparative negligence allegation. That's very important. Now here again, service and filing of an answer is more simple than for the plaintiff, because you don't have to serve the plaintiff at home. Now I've seen some defendants do that, and that's incorrect. You shouldn't even be doing that. Basically you serve the plaintiff's attorney, and you serve them by just filing copies with the court, and then the court usually has a mailbox set up for the plaintiff's attorney and just sticks it in there, or you can mail it to the attorney. You don't have to have a deputy sheriff go to the attorney's office, for example, and serve him with the answer. In fact, that would be downright dumb. And so basically, those are important. You always want to develop some kind of a checklist. You might look at that. Check everything over, make sure you've got everything stated correctly. I think that's important. Another thing real quickly, counterclaims. There are permissive counterclaims, and there are, basically compulsory counterclaims. So let me put those up here and talk about them. Now there is a difference between these two. And so I'm going to talk a little bit about them. So a permissive counterclaim, you can do it or you can not do it. You can sue them separately for that, or you can sue them as a part of a counterclaim. Either way. Let me give you a perfect example. You've got a guy that's living in a garage apartment, and he comes outdoors and he slips and falls on the stairs because it's an icy day. And so he sues you. I had a case like this. This is how I know. Okay, well what happens is he hurt his back really bad and he can't work. So because he can't work, he can't pay his rent. So the plaintiff sues the defendant for the ice on the steps that causes him to slip and fall and hurt his back. And then the defendant counterclaims against the plaintiff, claiming that he hasn't paid his rent. He's behind on his rent. He needs to pay his rent. And so basically, that's a kind of an interesting situation, kind of a funny fact scenario, but it actually did happen like that. So counterclaim could be permissive. Compulsory counterclaim is when there is a car wreck, let's say, and somebody hits another person. Let's go like this. The light turns red and the person stops, and the person behind doesn't stop and crashes into the car in front. So the person in front sues the car in back, claiming, oh, you hurt my neck because you crashed into me, you weren't paying attention when the light turned red. Well, the person behind says, no, you didn't stop at the stop line. You stopped 20 feet behind the stop line. You stopped in the middle of the road. You're not supposed to stop in the middle of the road. And so as a result, you wrecked my car, you hurt my neck, and I'm suing you in a counterclaim. And so in the answer, you would say that the plaintiff's comparative fault would be higher than the defendant's. And in the compulsory counterclaim, you would say that the true cause of the accident wasn't failure to stop at the red light, but the failure of the plaintiff to proceed up to the stop line, stopping in the middle of the road where you're not supposed to stop. You're never supposed to stop in the travel portion of the roadway. That's a rule. That's a Title IX rule in Indiana. You don't stop on the travel portion of the road. And so he would have never struck the person in the back end if they hadn't stopped well short of the stop line. I had a case like that too. So here again, basically you can see fact scenario, very sensitive on whether it is a compulsory counterclaim or a permissive counterclaim. Just a couple more quick points here. Basically what we're looking at, there are other things like crossclaims. In those cases, let us say that there is another plaintiff and you want to sue one of the plaintiffs, or there is another person that's not named in the lawsuit and you want to sue them, like the one I talked about the other day where the school corporation, the bus driver, failed to put the stop sign out. And so basically you have that possibility that the defendant could file a suit and say the true cause of this accident was the failure of the bus driver to put out that stop sign. So, this is another possibility, is what we call a cross-claim. One of the things that can be problematic for a plaintiff is failure to file an answer to a counterclaim. That can get you into a lot of trouble. So you want to, be very careful on that. Also, like we said, technical challenges like lack of jurisdiction. These can be in the form of motions to dismiss, motion for change of venue, motion to amend, words like that would say that the complaint wasn't done right in the first place. So that's another option. Okay, well, hey, that's basically it for this section. This is section 5. We will come back this is section 6. Sorry. And we'll come back with another session here in a little bit in section 7. So thanks for paying attention. I'm always there if you need me. Just go to communications, send me an email, or you can put up something in the discussion board, and I try to look at those very frequently. So stay in touch. I'll do the same, and we'll see you next time.